please. Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Dawson Whitman and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning. Welcome to the Appeals Court. Let me introduce the panel. I'm Justice Shin. Sitting with me today is Justice Grant, who is appearing by video conference due to unavoidable circumstances, and Justice Hershfang. As I'm sure many of you know, the rules of oral argument are each side has 15 minutes to argue, and we do not allow rebuttal. The last thing I'll say is that the panel has read all of the briefs. We're familiar with the record, so my best advice is to get to the heart of your argument. Okay, I'll call the first case, which is Commonwealth versus Carlos Torres, number 2024 P152. This case is partially impounded.
Yes, Your Honor.
Yeah, so just make sure that you don't, I believe it's the names, to not reveal the names.
Yes, Your Honor. May it please the court, my name is Daniel DiMaria, and I represent Carlos Torres, the appellant. This case presents a narrow but fundamental question whether Mr. Torres received a fair trial when the jury was never instructed that it had to consider each charge separately. The case turned entirely on credibility. There were no eyewitnesses, no confession, no physical evidence, and so the absence of instruction 2.300 result in a substantial risk of a miscarriage of justice.
My apologies, counsel. Sorry to interrupt. There is another reason why this case is impounded. It's now just occurred to me, which is that part of the case was sealed.
Okay, Your Honor.
Right? Do you agree that insofar as that information is relevant to the issues raised on appeal, those issues can be discussed here today?
Yes, Your Honor.
Okay, and you do realize that the opinion will have to refer to that information insofar as it's relevant to the appeal. Do you agree with that?
Yes, Your
Okay,
Honor.
thank you. Sorry, go ahead.
So instruction 2.300 states a jury must consider each charge separately and return a separate verdict of guilty or not guilty to each charge. Here, the judge never gave that instruction during the preliminary charge, during the final instruction. He never told the jurors to treat the three counts as distinct. All three counts were the exact same: indecent assault and battery on a child under the age of 13.
So, counsel, your argument has a facial, sort of superficial appeal, but where I ran aground trying to follow your argument was when I looked at the jury verdict slips, which are at pages 21 and 22 of the impounded record appendix. And each one of the counts articulates both the name of the alleged victim for that count and the body part alleged to have been touched. So it seems to me that the jury could not have ruled on those counts without being aware what the defendant's charge was in that count. What's your response to that?
Yes, Your Honor. Verdict slips cannot cure improper judicial instruction. Jurors take their directions from the judge. They don't go to the jury room and figure it out based on the paperwork. I will also say, Your Honor, looking at the jury verdict, it says count one, and on the other complaint, it also says count one. And so the fact all three are described as count one would surely have confused the jury in my view. I will also say we cannot just look at the verdict forms in isolation. Defense counsel begins his closing argument by saying there's an allegation. That's right at the start, implying all three counts are really one crime. The judge refers to that crime, again, giving the jury the impression this is all one and the same. And even the prosecutor in her closing argument said, find him guilty on all counts, not on each count. And so I would respectfully submit that the verdict forms do not help the issue at all. And I will...
What do we do, excuse me, counsel, what do we do with the fact that in the instructions, the judge said, and this is in volume 2, page 140, ladies and gentlemen, as you know, you have before you 3 separate counts of indecent assault and battery. You'll have with you 3 verdict slips, referring to the verdict slips that Justice Hershfang just described, that described separate counts with separate body parts. Why didn't that instruction incorporate by reference the verdict slips?
So I will say, Your Honor, that first of all, in my opinion, or in my view, jurors need to be told explicitly to consider each charge separately. That's number one. Number two, in Commonwealth versus Case, this court upheld a conviction precisely because not only did the verdict slips indicate they were, they were separate, but also because the judge gave the multiple charges instruction. And so I think without being explicitly told to consider each count separately, the jury may have been confused. I will note as well, the jury deliberated for 2 days on what was a very simple 3-witness case. That to me suggests confusion. The fact everything is labeled as count 1 suggests confusion.
Well, here's where I'm having trouble, counsel. This issue normally comes up in the context of greater and lesser included offenses. So here you have 3 counts. They're all charging the same crime. The testimony describes 3 incidents. So you have 3 acts and 3 counts, identical counts. Well, the crime charge is identical. So take me in the mind of the juror. How could they possibly have convicted him twice of the same act or on less than a unanimous verdict? So I'm in the jury room. I pick up the first verdict slip, and there's a vote, and they find him guilty, and then they pick up the second one, and then what happens?
I will say, Your Honor, perhaps Your Honor is simplifying things too much. I don't know how many verdict slips went into the jury room. There may have been 1. It may have been in the possession of the foreman. He may have read out count 1 is this,
But
count 1 is...
They know there are 3 counts, right? They're told by the judge there are 3 counts. They return verdicts on 3 counts of the same crime. So how could they possibly have not have convicted on the same act twice? I just don't see it. I mean, if you can take me into the mind of the juror and tell me what the risk is there, I'm not seeing any risk there.
So, Your Honor, if the foreman is in custody of the verdict slips and he's referring to count 1, I know there are 3 counts. I don't deny the judge said that. But if the foreman says count 1 is this, count 1 is this, count 1 is this, because they're all labeled as count 1, as they're deliberating, they may have mismatched their deliberations. They may have thought, hey, if we find him guilty of touching the vagina, he must also be guilty of touching the breast. Even the language at the top of the verdict slip is confusing. Rather than saying, we, the jury, unanimously return the following verdict separately, it just says it at the top. So I could see them conflating the counts and the evidence and saying, hey, because we found him guilty, or we think he may be guilty of this count, he probably committed that one as well. They were never instructed to deliberate separately. And again...
But doesn't the fact that they found him not guilty of one of the charges undercut that argument?
I would say no, Your Honor. I would say they may have simply split the baby where they couldn't decipher between the 3 during their 2 days of deliberation, and so they found him guilty of 2 and not guilty of 1.
But the 2 as to which he was found guilty pertain to the same victim. And the one as to which he was found not guilty was the other victim. So just to follow up on Justice Grant, doesn't that imply, or can't we read that to imply that they parsed the two different victims' testimonies and concluded one was credible and the other wasn't?
I would respectfully disagree, Your Honor. I think it shows the jury struggled, but it doesn't show they correctly applied the law to each count. Again, they may have simply found him guilty of the two counts because they thought something might have happened without actually agreeing unanimously as to which act. And that's precisely why we need the separate acts instruction. And so, again, between defense closing statement, the prosecution's closing statement, the judge's remark, that crime, I think the lines may have absolutely been blurred here. And the fact that the verdict slips all refer to count one, count one, count one. And again, I will emphasize the fact the jury deliberated for 2 days is indicative in my view. And so I would submit that in these circumstances, this court should order a new trial. Again, it's a credibility-only case, no confession, no physical evidence, no video evidence, nothing to corroborate, the total absence of a model instruction and the fractured deliberations. And if there are no questions, I would rest on my brief.
Okay, thank you, counsel.
Thank you.
Good morning. May it please the court, Emily Jamalowitz for the Commonwealth, asking the court to affirm the defendant's convictions. There was no error here in the judge's instructions, specifically on the issue of unanimity. The judge instructed on page 138 of volume 2, quote, "Your verdict on each charge, whether it is guilty or not guilty, must be unanimous." And then just 2 pages later, I think Judge Grant already quoted this language, but he then further instructed them, quote, "You have before you 3 separate counts of indecent assault and battery." If the jury followed those instructions, and we presume that they do, their verdict would have had to be unanimous on each separate charge. Where the judge provided those instructions, he wasn't obligated to elaborate any further, particularly absent any requests to do so.
How do you respond to the argument about the misnumbering of the counts?
I don't really think that matters. Certainly it was clearly a typo, but where the jury had the 3 charges listed very explicitly with both the victim's name and the body part at issue, where they also then had to check guilty or not guilty 3 separate times, I think what I would suggest was a typo on the jury slip doesn't really matter. In any event, I would argue that any error in those instructions, any sort of omission in the judge's instructions regarding the unanimity did not create a substantial risk of a miscarriage of justice. I won't belabor the point, but I do think the verdict slip, the importance of the verdict slip cannot be overstated. It was sort of abundantly clear which incident was at issue for each charge. I just don't really think that it's possible, particularly in the context of the instructions they received, for the jurors to individually check each box if they were not unanimous and knew what they had to do. And then just the second point I'd make is I do, I guess, respectfully disagree that the evidence in the testimony was confusing in this regard. No, the prosecutor didn't get up and say, count 1 is this, count 2 is that. But I do think she was pretty consistent throughout, discussing each incident in relative isolation. She used language like the first incident, the second incident, and so on. I think the jury got the point that there were 3 separate incidents for their consideration. And then
Did the verdicts, as announced in open court, use count 1 multiple times, or did it say count 1 and count 2?
my recollection is the clerk, I think, may have read count 1 twice, and then I think he may have moved on to count 2, and then the count 1 of the other docket. But again, I think where the jury had that verdict slip in front of them and they affirmed each verdict separately, I certainly don't think that there's a substantial risk here that they were confused at that point. And I guess I will just note, certainly the way the verdict came out is not just positive, but I do think it's significant. I think it kind of rebuts the idea that the jury sort of conflated all of these three incidents and came out, I guess, decided. It's the fact that they acquitted on one count, I think, is consistent with them having considered each charge individually. It wasn't just all or nothing because they were confused. They carefully weighed the credibility of each victim and decided accordingly. I guess if there are no questions, I would rest on my brief.
Thank you, Counsel. All right. The next case is Commonwealth versus MOHAMMAD ENAYAT, case number 2023 P1359. Did I pronounce your client's name correctly?
I'm so sorry, I didn't even hear what you said.
ENAYAT?
Yes, yes you did, thank you. And may I begin?
Yes.
Good morning, and may it please the court, Aaron Opperman on behalf of Mr. ENAYAT. I'm going to start by addressing the argument that relates to all the indictments other than the common and notorious thief, and that is that there was insufficient evidence that the defendant gave or caused to be given false information on the application to the dealerships. This obviously is an element of the larceny by false pretenses and false pretenses in obtaining credit. And the support for this argument is threefold. First, that during testimony, Mr. Baptiste, who was the salesperson for the first vehicle lease at the Land Rover Norwood, testified that he obtained the lease terms from the defendant, lease terms being the length of the lease, the monthly payment of the lease, and the business information, and that he spoke to Mr. Hargan to obtain the credit information. There was no elaboration on what additional information specifically he obtained from Mr. Hargan, but the assumption, the reasonable inference or assumption is that he obtained Mr. Hargan's personal details from him as in his capacity as the co-signer for this lease. Mr. Baptiste testified that he spoke to Mr. Hargan on the phone. He further testified that he observed Mr. Hargan speaking with the finance individual during the course of signing the paperwork, that he was engaged and alert and appeared to understand all the documents. Additionally, Mr. Hargan was asked a number of times whether or not he provided the information about the income and his employment. 5 times he testified, either I don't remember or I don't recall. And he was asked with increasing specificity whether or not he provided the information about his income and employment to Mr. Baptiste. And he repeatedly said, not no, I did not give that information. But he said, I do not recall, I do not remember, I do not recall that conversation. Eventually, the prosecutor pinned him down and he said, no, I did not give that information. Mr. Hargan did not testify, however, that the defendant, either the defendant gave the information himself or that the defendant
But
told
almost
him to give
everything
that
on this
information.
almost everything on this application was false. including the address and the phone numbers, which were the defendant's. The defendant was the one who benefited from these transactions. So why couldn't the jury infer either that he was the source of the false statements, or at a minimum that this was a joint venture?
Well, I think that the answer to that question is simply that that inference is too remote.
It's what?
Too remote.
Oh,
and simply that the prosecutor presented evidence in this case to get them 70% of the way toward beyond a reasonable doubt and didn't provide that additional information necessary for sufficient evidence in this case.
So by that additional information necessary, the additional 30%, I just want to make sure I'm following. In your view, that would have to be either testimony from somebody that it was actually the defendant who either wrote that information or caused it to be written on the form. Is that what you think is missing?
On the specific facts of this case, yes. In a different case, possibly not. But when you have a neutral, disinterested witness, such as Barry Baptiste, who testifies he spoke to Mr. Hargan on the phone, Mr. Hargan looked engaged, alert, and as if he was understanding the conversation about the documents with the finance manager, and Mr. Hargan testifies differently than that, to me that's a very clear sign that Mr. Hargan is not being completely honest. So in this particular case, where you have affirmative evidence presented by...
So are you asking us to find that Mr. Hargan was not credible when he testified that the defendant persuaded him to sign these credit applications?
So I don't think that... First, I don't think that Mr. Hargan testified specifically that the defendant told him to sign the credit applications. There was some testimony that, quote unquote, the defendant shoved paperwork in his face and said, sign here, which I think is not believable in light of the testimony that there were dealership employees sitting with Mr. Hargan and the unlikelihood that that would have been acceptable to the dealership. But I'm not asking the court to directly find that Mr. Hargan was not credible. I don't think that's necessary. What I am asking the court to recognize is that in light of the fact that there was testimony by Mr. Hargan, who was biased, was interested, had been given a non-prosecution letter in this case, so clearly at some point was under some extent of investigation by the prosecutor's office, when his testimony contradicts and conflicts with who is an unbiased, disinterested person about where that information came from, that is insufficient evidence for guilt. So I think implicitly the court should recognize that the credibility of Mr. Hargan was in direct conflict with the other prosecution witness on this point. And in its brief, the Commonwealth consistently states as if it is objectively true, the defendant told Mr. Hargan to provide this information when there is simply no evidence of that fact. What there is evidence of is that Mr. Baptiste got information relevant to a co-applicant from Mr. Hargan and got information relevant to the lease terms and business from the defendant. So I think in the end what the Commonwealth is urging with respect to this element, which again applies to all 6 indictments, is that the court should just assume that the defendant provided this information either to the dealerships directly or to Mr. Hargan. Where there is a complete absence of that evidence, and in light of the questionable credibility and the conflict of testimony, that simply is too remote of an inference to satisfy the sufficiency of the evidence standard on that element. With respect to the element on the larceny by false pretenses indictments, of which they were 3, obviously the defendant is also arguing that evidence was insufficient, primarily because there was no evidence and there's insufficient proof that the dealerships parted with their vehicles because of these false statements. The Commonwealth appears to be arguing for some sort of attenuation. the dealerships accepted these applications, transmitted them to the banks, and they wouldn't have done so without these false statements. But again, there is no evidence that that is the case.
I'm not sure that's quite right as an expression of the Commonwealth's argument, and obviously I'll ask ADA about this, but my read of what they were arguing was that the dealerships had parted with their vehicles because the bank provided a loan based on the false information, not whatever you said, which I cannot currently recall.
And I agree with that. And maybe I'm just saying it a little differently or taking my inference of their argument one step further. But assuming that the way Your Honor phrased it is exactly accurate, I still think that's not enough for sufficiency of the evidence on the larceny by false pretenses indictments.
Well, let me ask you this, and again, this is not really your question, so I'll try to be brief about it, but the dealerships were paid, is that correct?
Correct.
So the dealership said, we're going to sell this car for X dollars. They got X dollars, they sold the car. The bank was out the money, presumably?
Correct.
The bank is not a named victim on the larceny by false pretenses indictments?
Correct.
Thank you.
And I think that the proper way to charge that would have been to name the banks as the victims. And I think with respect to whether there was a larceny by false pretenses crime committed in this case, assuming the other elements were met, which of course the defendant is arguing that they're not. The victim of any larceny by false pretenses crimes is the bank. It's not the dealership, and they're two separate entities.
Are you saying that the fact that the dealerships were paid negates the offense? You're not arguing that, right? They don't have to be damaged in order to be the victim of the...
No, I'm not arguing that damages per se is an element, and I wouldn't use the word negate because, of course, my position is there was no offense, but I am arguing that the dealerships needed to have parted with their vehicle on
relying on...
principally motivated by these false statements.
Okay,
and
so
I think
Baptiste testified that had he known that this was a straw purchase, as he put it, he wouldn't have gone through with the deal, that he would have reported it. So your argument seems to be that the dealership doesn't care one way or the other whether the information on an application is false so long as they get paid. But he said if he knew that it was false, he wouldn't have followed through.
So I don't agree that that was what he testified to. I think the testimony about a straw purchase in this case was a bit of a red herring and was incomplete. I think, first of all, this was a company lease. This wasn't Mr. Hargan in his capacity as an individual applying for a car and then just completely letting the defendant in his capacity as an individual exclusively use the car. This was a business lease, and the defendant's business was on the lease. So with respect to all of the testimony about a straw purchase, I would ask the court to just put that aside because the testimony was incomplete. Mr. Baptiste testified to generally what a straw purchase is. He said it wasn't illegal. He said they don't engage in them, but he didn't elaborate on that. There was no language about a straw purchase in any of the documents filled out, signed. So I don't think...
Excuse me, you say that it was a business lease, but wasn't one of the misrepresentations that Mr. Hargan was the president or treasurer of ABC Fine Rugs? And did he have the authority to bind ABC Fine Rugs?
Bind?
Bind, yes. Isn't that one of the misrepresentations?
So one of the misrepresentations was the claim that he was the president, correct. But he did also testify that he served in various positions with the company. Ms. Holcomb testified that Mr. Hargan worked for the company, and Mr. Hargan said himself that he did sporadically help the defendant and was paid in, quote, money and gifts. So there was certainly a discrepancy on how he was paid, what he was paid. He didn't specify exactly what money he received from the defendant, but to the extent that that was a false representation, I'm not sure that the falsity necessarily indicates that he wasn't, one, that he wasn't capable of binding the company. Two, I don't think there was any testimony that the co-signer had to be associated with the company, so that would be a link missing in that regard.
But it's not that he had to be, it's that he called himself the president. He said, I'm the president of ABC, I don't know about he said, the form says.
Correct, correct.
I'm the president, I make $150,000 a year. None of that was true. So whether or not it was necessary for him to have a role at all or a C-suite role, he didn't.
Correct. We do know that he testified that he served in various capacities, quote, on the papers. So to what extent he was associated formally with the company is unknown. And again,
Well, wait a minute. He testified, what was the position he assigned you? At one point it was treasurer, at another point it was president. And what did that mean? Nothing to me, because I really was not either one of them, but he wanted them for the papers. This is at volume 2, pages 153 to 154. Are you asking us to decide that Mr. Hargan was not credible when he testified that he was not in fact the president or treasurer, but just said he was because the defendant wanted that for the papers?
no, that's not the request I'm making right now. The request I'm making is for the court to recognize that the evidence showed that the dealerships parted with their vehicles because they were paid by the bank. And that if, assuming the other elements of larceny by false pretenses were met, that the victim in this case would have been the banks, not the dealership. And there's simply insufficient evidence that the dealerships, that the dealerships parted with their vehicles because of these false statements. With respect to the other 3 indictments, the material reliance by the banks in allowing credit, again, I would urge the court to find that there's insufficient evidence based solely on the applications. I've elaborated on this argument.
Your time has expired. We do have your brief. Let me just make sure there are no further questions. Okay, thanks very much.
Thank you.
Good morning, Your Honors. May it please the Court. Kyra Kosh, Assistant District Attorney from Middlesex County on behalf of the Commonwealth. The defendant's sufficiency arguments all boil down to asking this Court to view the evidence in the light least favorable to the Commonwealth, which this Court cannot do. In the light most favorable to the Commonwealth, Hargan's testimony that he did not provide those false statements and that he did not speak to Baptiste or any sales representative over the phone are true. Hargan repeatedly testified that he did not know as to each vehicle that the defendant was having him guarantee the lease. He showed up under essentially false pretenses there. He thought he was there to have the vehicles serviced, and then the defendant put the documents in his face and said, here, sign this. And as Justice Shin pointed out, the defendant was the one who benefited from each of these transactions. Hargan did not even test drive these vehicles. The defendant was the sole person who ever drove these vehicles or for his business, which, as Your Honors pointed out, Hargan was not actually a member of this business. He would occasionally mind the shop, but he wasn't paid for doing so. He was just given small tokens or gifts, which were essentially just items that the defendant no longer wanted. And when you look at those actual false statements, they all pertain, for the most part, to the defendant himself. For the first 2, it's his residential address that's on those documents. For the third, it's his business address. It's the defendant's phone numbers who are on each of them. So that points to the defendant being the source of those false statements, even if it is a joint venture, which I submit in the light most favorable to the Commonwealth. There was not enough evidence for that, but regardless of how this court views the testimony, there was sufficient evidence from which this court concluded that it was the defendant who made or caused to be made the false statements. As to the dealership's material reliance on those false statements, as well as the bank's material reliance for the false pretenses in a credit transaction, the financing applications clearly state that both of those entities will rely on those false statements, on the statements therein in making their decision. And the Baptiste, the sales rep from Land Rover, also testified that when selling or leasing a vehicle, the dealership takes an application to get the position of the guarantor, which involves acquiring information related to income. And they would also consider a company credit card, like the fake one that was provided in this case, to Land Rover to verify the guarantor's employment. And it's also just plain common sense that the dealerships and the banks would materially rely on statements about income and employment when deciding to issue a loan or give someone a car.
What do you say to defense counsel's argument that the dealerships should have been named as the victims in the larceny indictments?
So it's been the law since 1839. I'd point you to the case Commonwealth versus Call, which is at 38 Mass 515. Larceny by false pretenses encompasses scenarios where one's property is obtained, but the loss falls upon another. The false pretenses were submitted to the dealership first through the financing applications. They're processed through the dealerships, and then that application is submitted to the bank. So the false pretenses are practiced upon both of them, but although the ultimate loss is upon the bank, it is still larceny by false pretenses upon the dealership as well.
I read Call a little differently. In Call, I read that case as resting up on the former agency relationship between the defendant and the two alleged victims. The defendant used to be their agent. Unbeknownst to the person from whom he went to collect money, he was no longer their agent, right? But he goes, and in his role as their agent, he gets the money that is owed to the victims and then just never turns it over to the victims. I don't see how that kind of lays squarely on the situation here where the dealership and the bank are separate businesses. And if we look at, so who ended up with the loss here?
Essentially the banks, although the dealerships also did part with their vehicles.
The dealership.
But they were made whole.
Okay.
As far as the income was. But Commonwealth versus Lepper at 60 Mass Appeals Court 36 also says that the fact that the victims are made whole does not negate the criminality. Neither the intent to repay nor actual repayment, whether it is from the wrongdoer or some other third party, is not a defense to larceny by false pretenses. And the judge did instruct on that as well. The crime is committed at the point the property is intentionally obtained in material reliance on the false statements, regardless of the pecuniary, whether they were made whole or not.
Why wouldn't the Commonwealth name the banks as the victim or a victim in these larceny counts?
So the Commonwealth certainly could have put on a witness from the banks, but given the statements in the financing applications themselves and the statements from the witnesses from the dealerships, it was not necessary. And there was...
No, I agree with you on that. Sorry, I wasn't asking about the evidence. Obviously, the Commonwealth will try its case in the way that it feels is necessary, and maybe it'll work and maybe it won't. But in terms of the charging documents, there was a choice made at some point to name a victim for this larceny, and the choice was to name the dealership. My question is, why not name the bank or name both the dealership and the bank to avoid these questions that you're having to answer?
I think due to the fact that there's the false pretenses in a credit transaction counts, which has to be the bank as the victim because the property that they're parting with is credit, which is required for that count, those counts. Whereas with larceny by false pretenses, it's property. This was charged under Section 30, not Section 34. So that's why the banks weren't named victims.
Is it a lesser included?
I don't think they're lesser included. I think Greenberg, I believe, is the case that makes the distinction on those two offenses. That larceny by false pretenses surrounds property, and false pretenses in a credit transaction is credit as the res. So moving on to the bank's material reliance. Again, it's in the financing applications that they will rely on those statements in making their decision. And although the facts are essentially the reverse as in Duddy Ford, that case is instructive. Although, again, there was no witness from the banks to testify to the material reliance, there was similar testimony from the dealership witnesses. Michael Knutson from the Land Rover dealership said that in his job as the financing director, his job is securing the loan with the customers and completing the paperwork, and that he submits the applications to the bank, who use that information specifically as to the employment and the salary in order to secure the financing. The banks make their decision based on that information that's in the financing applications.
How is he qualified to say what the bank relies on or not?
Well, his job is essentially working in tandem with the bank to secure the loan. He is essentially the agent from the dealership that submits those applications and works with the banks to secure the financing.
Didn't the judge sustain an objection to a question that tried to go there?
They did, but immediately after that testimony, which is on, let's see, where's the exact site? It's volume 2, page 218. Immediately after the sustained objection, the prosecutor says, how is that information used? And the answer is, that's what the bank would use to make the decision whether or not someone would be able to be approved for a loan or not. And that was not objected to. And also during Julie Holcomb's testimony, she testified that she understood the bank would rely on the information being provided in the financing applications. Now, of course, although the defendant was acquitted of the indictment surrounding Julie Holcomb, the court could still consider that based on the fact that it wasn't identical, essentially, financing applications that was submitted. Although Hargan gave testimony to the contrary, it's clear from his testimony that he didn't totally understand what was happening with the documents. He thought that he was just signing his name, but it was the business who was obtaining the loan ultimately. He didn't recognize his responsibility and liability for those loans. And also, Duddy Ford says that common sense dictates and the jury reasonably could infer from the evidence presented that the banks relied upon the statements.
So let's say everything on the application was true, except for, say, the income. Would the evidence then be sufficient?
I would say so, Your Honor. I think in any transaction where property is exchanged for money or you're trying to obtain a loan, that the creditor is going to care about your ability to pay.
Let's say everything is true except for his title at the company.
I would still say so, yes, because this was a business lease, as Your Honor's pointed out.
But so we just assume in every case that if there's a false statement on an application, that the bank relied on it.
Well, maybe if it's not something minor that doesn't pertain to the transaction, say if he put his birth date wrong, for example, I wouldn't say that that is something that's material, but something that relates to income, employment, anything of that nature would amount to false pretenses that are material in a transaction such as this.
Just as a matter of common sense, we just extend common sense without evidence that there was reliance on that.
Well, yes, in common sense, but there's also the evidence through the financing applications and the testimony provided by Michael Knutson and Barry Baptiste.
Yeah, I mean, I think this case is stronger for you because almost everything in the application was false, but, you know, once you're getting to just one misstatement, it might be taking it too far to say you just rely on common sense.
Oh, correct. It depends on the exact situation and what the false pretenses were in general, of course. I'm not saying that common sense alone is sufficient in every case. That is not the argument that I'm making. So in case the court has any further questions on the sufficiency issues, I'd like to move on to the missing witness instruction. Okay, so the judge properly denied the defendant's request for the missing witness instruction. The case law is clear that even if the foundational requirements are met, the judge has the discretion to deny that instruction if the adverse inference is not warranted on the facts, which, as I had just argued, the inference is actually in favor of the Commonwealth as to the material reliance by the banks on those false statements. If the judge would have instructed the jury that the Commonwealth did not present a witness from the banks because the banks would have testified that they did not materially rely on those statements, it would have been, as the judge said at transcript volume 4, pages 148 to 149, it calls for significant speculation and a huge inferential leap from the evidence to ask the jury to infer that the Commonwealth knew that the banks were going to testify that they did not rely on the false statements at all. But in any event, trial counsel was still allowed to point out to the jury that the Commonwealth did not present a witness from the banks, and therefore the Commonwealth failed to meet their burden of proof as a result. That is the proper argument for defense counsel to make on the facts that were presented at trial. So as for the closing argument, just considering the statements in light of the closing argument as a whole, the jury instructions, and the evidence at trial, these did not create a substantial risk of a miscarriage of justice. Each were all appropriate comments made based on the evidence and/or reasonable responses to statements made in defense counsel's argument. I'm happy to rest on my brief in case this court has any further questions.
Okay, I see no further questions, so thank you very much. The
Thank
case
you.
is submitted. All right, the next case is Commonwealth versus Joshua URIEL Negron, case number 2024 P746. Counsel, did I pronounce your client's name correctly?
I believe you did.
Okay, thank you.
Thank you. May it please the court, Catherine Sullivan Ledwidge on behalf of the defendant Joshua URIEL Negron. The defendant's conviction of assault and battery causing serious bodily injury should be reversed because the Commonwealth presented insufficient evidence to support a finding of serious bodily injury. Serious bodily injury is defined by Chapter 265, Section 13A(c) as a bodily injury resulting in permanent disfigurement, loss or impairment of a bodily function, limb or organ, or a substantial risk of death. In this case, the Commonwealth proceeded under the loss or impairment of a bodily function prong of the statute. And the judge only instructed on that prong. When we look at impairment of bodily function, the court, there's not that many published cases on this, but it started in Marino and Scott. And in Scott, the SJC talked about the degree of impairment contemplated by the statute. And they said it's best understood when you consider the phrase along with the neighboring word, loss, and the other two clauses, permanent disfigurement and substantial risk of death. And they said the loss of a bodily function would have a substantial impact on a victim, on a par with injuries causing permanent disfigurement or risking death. And these conditions suggest significant effects on the body. And for this reason, the SJC rejected the Commonwealth's argument that any injury would constitute an impairment under the statute as long as it was more than merely trifling or transient. And while it need not be permanent to be a serious bodily injury, a review of the cases that have been discussed, that discuss the issue, demonstrates that it is not an impairment that is short-lived. So in a 2020 case, Commonwealth versus Haywood, the defendant sustained punches in the face, and he had a fractured cheekbone, a fractured right orbital bone, and retinal bleeding. It required surgery to repair the structures of his face, and he had to have 2 titanium plates surgically inserted into his face to hold his bones in place. As a result, the defendant suffered nerve damage to the right side of his face. It was chronic numbness. The victim could barely feel the right side of his face, and he testified that it felt like he had Novocaine.
What do we do, excuse me, counsel, what do we do with the fact that in Haywood, the victim testified that there was a visible indentation in his face after the defendant's punch? And in this case, the victim testified that she could still feel the little void under her eye. Doesn't that make this case similar to Haywood?
Well, it doesn't, because they didn't, the judge never instructed on permanent disfigurement. And in Haywood, that was the indentation in the face was relevant to the permanent disfigurement prong of the statute. So the impairment of the bodily function in Haywood had to do with the fact that it was the chronic numbness and that it was the impairment of the bodily function of the system, the peripheral nervous system. So that's the difference in that case.
So here we have, would we agree that seeing is a bodily function, vision?
Vision is the bodily function.
And it's obviously not a loss because the victim can now see again, but she testified that for something between 1 and 3 weeks, it's not entirely clear, she either couldn't see at all or had obstructed vision out of her affected eye. Why doesn't that meet the standard?
Well, I suggest it does not meet the standard because the obstruction to her eye resulted from not the bruising, and the bruising was 3 weeks at the most. She said it was the swelling, and if you looked at what the doctor said, it was the swelling that caused her to be unable to open the eye. And when she was asked to testify as to swelling, she said I'm pretty sure she said she wasn't sure or she didn't remember. But she did say that the pain, she was in pain and that lasted, and it was pain when she moved her eye to the right. But when she was asked about pain, she said it lasted about a week. And so my point is that is short-lived. It is not chronic. It doesn't have to be permanent, but I don't think the statute contemplates, based on what the SJC was saying in Scott. When I look at all the cases that interpret the phrase loss or impairment of a bodily function, that would be on par with permanent disfigurement, risk or resulting in risk of death. My position is that it has to be something a little more ongoing.
Right, you just think this isn't enough, right?
It's not enough. It's just, if I look at all the cases, I've done a survey of published and unpublished, and the least amount of time I've seen is a month. And I don't want to point to the unpublished because I'm not supposed to, but the published, 6 weeks was the lowest one, and that was a broken jaw. And then in another one, it was vision changes, and that was he couldn't see out of his eye for a month and a half. And so that's really what I'm talking about. And she didn't even say, I couldn't see for 3 weeks. She didn't say that at all. She said, I can see fine now. And she said she had pain for a week, and she had swelling, and she couldn't remember how long that lasted. So she was told to ice her eye, keep the bed elevated, and that was for 24 to 48 hours. So I just can't see how, even if we say it lasted 48 hours to a week, I'm just saying it's not enough in this case to qualify, to raise it from assault and battery to aggravated assault and battery. And that's really comparing all the cases on the subject.
She did suffer broken bones.
Right. But the statute doesn't say broken bones. It says impairment of a bodily function. And the bodily function of the vision was not impaired because of a broken bone. Maybe if the muscle had gotten stuck and trapped in the fracture, which the CAT scan originally suggested, and that's why they called the ophthalmologist to come out and look. And she said, no, it wasn't. And that's diagnosed based on clinical. It's not diagnosed based on a CAT scan. So, I mean, I might not have an argument if it had been and she required urgent surgery and there was a longer term issue where maybe there would have been double vision or something like that. But my argument is the only thing preventing her from seeing was the swelling. And we don't know that that lasted more than 48 hours, even if it lasted a week. I'm just saying that's just not enough under the statute in this. And so I would ask that you reverse the defendant's conviction on count 1. And other than that, I would rest on my brief.
All right, thank you, counsel.
Thank you very much.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth, and with me at council table is the trial prosecutor in this case, Rita Muse. Turning to the first issue, Your Honors. The trial judge properly denied the defendant's motion for a required finding of not guilty as to count 1, where the Commonwealth proved the element of serious bodily injury beyond a reasonable doubt. In this case, the evidence was sufficient for a rational jury to find that the victim suffered a serious bodily injury by the loss or impairment of a bodily function. And I think it's important to frame this issue and discussion with the legislative purpose in specifying serious bodily injury as a form of aggravated assault and battery, which is to impose more serious penalties for more serious injuries and assault and batteries that result in more severe consequences to a victim. And significantly, these impairments and consequences need not be permanent, and the statute sets no required time for the length of impairment, and nor does the case law. So in this case, where the defendant punched the victim in the face with enough force to break her eye socket, leaving her with temporary visual impairment, the loss, which would be considered the loss of the full function of her eye, subsequently followed by pain lasting at least 1 week, a little bit unclear in the testimony, bruising lasting 2 weeks, and a void under her eye that was still present more than 2 years later at trial. The Commonwealth has satisfied this legislative purpose. And
what do you think, just to follow up on the back and forth with Justice Grant about the void under her eye? I mean, there's no, and maybe I'm wrong about this, I can't think of a bodily function that is impaired by having a little void under your eye, and that was the Commonwealth's theory.
So I think we don't really know, unfortunately, because this is a case, and I think this is significant to this case, where although the victim was told to follow up and follow certain instructions to see a specialist because this injury could have some very severe consequences, she didn't do that. And maybe for good reason, we don't know why she wasn't able to do that. So unfortunately, we don't know if there are other implications resulting from the void in the eye or the injury in general, but I do think what you have, the evidence at the time of her discharge combined with her trial testimony is certainly sufficient to go before the jury and for the jury to find serious bodily injury in this case. And that testimony consists of the EMT's testimony, the expert witness, the doctor's testimony, and the victim's testimony. Now, the EMT testified that this was an orbital blowout, and this court has found, although the lasting implications of that injury differ in some of these cases, this court has found in multiple cases that an orbital blowout, a fracture of the eye socket, is a serious bodily injury.
In all of the cases, in all of those cases that I've read, which I do not pretend is all of those cases, there were additional serious consequences. Is there another case that you know of like this one where it's only the eye socket fracture?
So I wouldn't say that it's only, I would say that there was a visual disturbance in this case and pain, and that although we don't have that lasting for months or, it might have just been a week in this case. Like I said initially, where the statute sets no time requirement, there's no bright line rule here for how long that impairment has to last. I think it is enough. And one case that is not cited in my brief I just found very recently when preparing for argument is Johnson 92, Mass App Court 538. That's a 2017 case. And I think it's interesting. There's a visual disturbance as a result of a concussion, and there's no length of time specified in that case. It does talk about how the victim missed work for 1.5 months due to the implications of the concussion, but it doesn't talk about how long the vision symptoms last. And I think that's significant because there's no specified time, and I don't think the court could specify a time for an impairment to last where this is such a fact-specific analysis. And if you look again at the EMT's testimony, she testified that there were several bones of that part of the nose and eye socket that were fractured, that the left eye was really swollen and her right eye was blurry. She had some visual disturbance at that time. Her pain was a 10 out of 10 before she got into before she went to the hospital. She was, I think some important evidence of that is she was requested to sign a document at that time and she wasn't able to because of her visual disturbance. The doctor also testified about the implications of such an injury, and again, we know what happened when she left the hospital, but we don't know about any further implications that may have come from this serious injury in this case.
Well, but we do know, I mean, in volume 4, page 56, we do know that when she was sitting there at trial, she was asked, do you have any pain today on your eye? As you sit here today, do you feel any pain? No. Is there anything that you feel as a result? Yes. What's that? When I go like this, I can feel the little void under my eye.
Yes,
right?
that's true. So 2 years later, we know that she didn't have a visual disturbance and she didn't have pain. But the doctor also testified at the time of her release, her eyes weren't functioning properly and recommended these follow-up instructions that she should see a specialist because with this type of injury, she listed a couple of things that could happen down the line long term. When you have a fracture in the eye socket, it can lead to changes in the position of the eye, function of the muscles that could lead to double vision. We know she didn't have that, or asymmetry and how the eye looks. So we don't know because she didn't consult with a specialist afterwards if any of those things came to fruition. But I do think what you have at the time of the injury happening is sufficient for serious bodily injury. And then, of course, we have the victim's testimony about the pain that she felt at the time that lasted about a week, bruising for a couple of weeks. And although her vision was no longer impaired, she did have that void that we don't have enough medical context to know what that means, but she did have that void at the time of trial 2 years later. If the court has no further questions as to that issue, I can move on to briefly the body-worn camera issue. As to the second issue, this was properly admitted where the footage showed the victim's injuries at the time that they were inflicted, and it is probative of both the nature of these injuries and the victim's state of mind at the time of the incident. I think this is a perfect case that is on par with Commonwealth v. Gilman that's cited in my brief that talks about where the prejudice flows directly from its properly probative effect to illustrate the nature of the crime and the defendant's involvement of the crime, the evidence comes in. And in this case, there was prejudice, but it was not unfair, and I think the case law supports that. And it also was not cumulative, where it showed her state of mind at the time when the defendant's argument was basically an attack on her credibility and the nature of the injuries where serious bodily injury was at play here. If the court has no further questions, I'll rest my brief.
All right, thank you very much. The case is submitted. Justice Grant, are you okay taking a fourth case before the break?
Fine.
Okay. All right, we'll hear one more case before our mid-morning break. The next case is MARK KON and others versus BETH FISHMAN and others, case number 2024 P1125. And I understand the appellants are splitting their time 8 minutes and 7 minutes? 11 minutes and 4 minutes. Okay, thank you.
Good morning, and may it please the court. Lawrence Kolodny on behalf of the appellant Craig Rogers. This is an appeal from Dr. Rogers' anti-SLAPP motion in the Superior Court, which was denied at stage 1 of the Bristol asphalt framework based on the judge's conclusion that the claims against him were based on non-petitioning activity. This decision is subject to de novo review, and we believe it was incorrect and should be reversed for 3 reasons. First, an objective reading of Dr. Rogers' actions actually recited in the counterclaim pleading shows that they were all either A, petitioning activity, such as providing assistance for the lawsuit or discussing settlement, or B, innocuous activity that could not reasonably form the basis of any claim. The pled claims against Dr. Rogers thus have no substantial basis other than or in addition to petitioning activity, which is the test at stage 1 of Bristol asphalt. Second, appellee's 2 main examples of supposed non-petitioning activity, a conversation described in the so-called Gillespie affidavit and the emails comprising the so-called misinformation campaign, do not actually provide a substantial basis for any of the claims against Dr. Rogers. The Gillespie affidavit is not itself a pleading, nor does it include any explanation of any of the facts that were actually pled. It also fails to recite any wrongful acts by Dr. Rogers that could have damaged appellees. The misinformation campaign, which is described in the pleading in paragraphs 95 to 98, includes no acts by Dr. Rogers that could have caused the injuries for which appellees seek redress.
What about paragraph 81?
Excuse me, Your Honor?
What about paragraph 81?
Paragraph 81 describes the conversation between Dr. Rogers and one of the appellees, Jesse Zorfus. That was not part of the misinformation campaign because the misinformation campaign was described in the pleading as a series of emails that were directed to the other minority shareholders. The conversation with Mr. Zorfus took place after the complaint was filed and was discussing settlement terms on behalf of the plaintiffs in this case with the appellee group, which includes Mr. Zorfus. So there's no allegation in the complaint that conversation with Mr. Zorfus was part of the misinformation campaign. And in any event, it was a settlement discussion, would have been covered under the SLAPP statute under Plant versus Wiley.
Courts have been able to consider affidavits at stage 1 since the Duracraft decision. So why isn't it appropriate to look at the Gillespie affidavit and the other one?
Your Honor, it is okay to look at affidavits at stage 1, but as Bristol Asphalt footnote 21 makes clear, the purpose of looking at those affidavits is to determine whether the facts pled in the pleading constitute petitioning activity within the meaning of the statute. The Gillespie affidavit describes a conversation that is not even alluded to, hinted at, or otherwise suggested in the pleading as being part of the.
All right. I mean, I don't take that much meaning from footnote 21. What you're citing are the parentheticals, but that footnote was in the context of the discussion of the appellate standard of review. Right. So the court was clarifying that we review both steps for de novo, and then there's this footnote talking about how courts can consider affidavits, but that's also documentary evidence that makes it appropriate for the standard of review to be de novo. I don't see any limitation in there about when you can consider affidavits.
Well, Your Honor, I understood that footnote to say, well, the footnote says a motion judge may need to look at other documents, and other documents meaning documents other than the pleadings, in the anti-SLAPP record to determine whether these factual allegations, referring to the allegations in the pleadings, fall within the statutory definition of petitioning activity. And Bristol Asphalt is clear that to survive the first stage, the proponent must show that the challenge count has no substantial basis in conduct other than or in addition to the alleged petitioning activity, And at the first stage, the court need only conduct a facial review of a special motion opponent's pleading to identify which factual allegations serve as the basis of a particular claim. So I think the proper understanding of Bristol Asphalt is that you look at the pleading and you try to identify whether there's any factual allegations in the pleading that support a claim that are not, which are not petitioning activity.
Bristol Asphalt returns to Duracraft, which says at stage 1, you consider the pleadings and the affidavits.
Well, I understand that it says that, but I think Bristol Asphalt clarifies that the purpose of looking at non-pleading documents is to clarify or put in context the statements in the pleadings that allege the factual basis for the cause of action.
In that case, they could have just amended their counterclaims, right?
I'm sorry, Your Honor?
They could have just amended their counterclaims to include the allegations.
They could have done that, but they did not, and I think the purpose of the anti-SLAPP statute is to understand why the complaint was brought in the first place, whether it was an attempt to attack the defendant for exercising petitioning activity. In this case, I think it's clear based on what the complaint actually says that the reason for filing this complaint was because Dr. Rogers funded the lawsuit and because he participated in the settlement discussions on behalf of the plaintiffs. I would also say that if you look at the Gillespie affidavit, even if it was included as part of the complaint, it would not have served as a substantial basis for any of the claims. And that's because the Gillespie affidavit simply recites this conversation that Dr. Rogers allegedly had with Gillespie, who was the potential buyer of the appellee's interest in the corporation. And Dr. Rogers simply expresses his opinion about how the corporation governance works. And Gillespie, who had already told, it's in the complaint, Gillespie told the appellees why he terminated the agreement, which was because of the filing of the complaint. He had every opportunity in this affidavit to say, and Dr. Rogers' statements caused me to terminate this agreement. Gillespie never said that. He simply provides this list of statements, and then he said, oh, and we terminated the agreement. And the statement that he made to the appellees when he terminated the agreement was, we're terminating it because of the filing of the lawsuit.
Why doesn't that go to the merits of the claim as opposed to the anti-SLAPP motion?
Because I would say that the facts that are alleged in the Gillespie affidavit do not actually provide substantial support in the sense that even if they were all true, those facts don't show how Dr. Rogers' actions injured any of the appellees.
And maybe that's a basis for a 12b6 motion. But under anti-SLAPP, we just look to see whether there's any basis for the counterclaim that's not based on petitioning.
Well, I think it has to be a substantial basis, Your Honor, and I would say that alleging a set of facts that don't contribute to the actual cause of action, that would not be sufficient under a 12b6 motion to make the cause of action more likely than it would have been without those facts, and I think that's the case here because we already know from the complaint exactly why Gillespie terminated the agreement. He terminated it because the lawsuit was filed. He told that to the appellees repeated that in their complaint, and so the fact that Rogers had this separate conversation with Gillespie after the complaint was filed really doesn't add anything to the cause of action, and it can't be the case that a party can avoid an anti-SLAPP motion just by reciting extraneous facts that don't actually support any of the causes of action. And I think, specifically, in particular, the abuse of process claim in this case is entirely based on the filing of this complaint and the supposed bad faith reasons for it and the supposed lack of merit to the complaint. And I think under the recent Hidalgo case that this court decided, which after our opening brief was filed in last December, an abuse of process case is prima facie subject to the anti-SLAPP statute, and there's no basis of bad faith or wrongful purpose to accept abuse of process claim.
We need to reconcile Hidalgo with Keystone. And in Hidalgo, it seems pretty clear that the basis of the claim was simply that the lawsuit was frivolous. Here you have allegations about an ongoing scheme, and they say the litigation was just part of that scheme, what they call the extortionate scheme. So why doesn't that put this case more in the Keystone realm rather than Hidalgo?
Well, I would say, Your Honor, in Keystone, the court made clear that in order to take the case out of the anti-SLAPP statute, there needs to be an allegation of a wrongful action by the defendant. And I would submit that if you look at the pled allegations, and including the Gillespie affidavit, nothing Dr. Rogers did in any of these scenarios was an actionable wrongful act. He helped fund a lawsuit. He just conveyed a settlement position to the opposing party on behalf of the plaintiffs. And then he had a conversation with the potential investor in which he described his opinions concerning the way that the bylaws operated in the corporation. I would say none of those are wrongful acts in the sense that we had in Keystone, where there was a clearly fraudulent scheme to overcharge the.
And again, why doesn't that go to the merits?
Well, I would say it doesn't go to the merits because, again, the issue here is whether these allegations provide a substantial basis for the claim. If these were the allegations in the complaint on a 12b-6, and that were the only allegations, they wouldn't support the claim because there's no causal connection between what Dr. Rogers supposedly did or anything wrong, anything that could be considered wrongful that he did, any harm that was incurred by the appellees. So I think you need to say, even assuming Rogers did everything that is said in the Gillespie affidavit, in the complaint, these are completely benign activities that could not be considered the basis for a cause of action if there wasn't something else. And the something else here is they're alleging that the complaint itself was brought for bad faith reasons and harmed them because the filing in the complaint undid their purchase and sale agreement. And that's really what the crux of this whole dispute is about.
Okay, thank you. Your time has expired.
Your Honor.
Good morning, and may it please the Court. My name is John Day. I represent the original plaintiffs in this matter, MARK KON, Ruben Rosales, and David Herman, individually and in their capacity as representatives of the Cambridge Towers Small Owners Association. I'll refer to them as the small shareholders to be consistent with our earlier briefings. Generally speaking, the small shareholders' position is substantively the same as Dr. Rogers, and so therefore we would incorporate Dr. Rogers' argument, which is that essentially the counterclaims state no substantial basis other than the petitioning activity and therefore should be dismissed pursuant to Section 59H. I do want to identify, though, two specific areas that are unique to my clients that did not involve Dr. Rogers as alleged in the counterclaims. The first one is it's referenced in paragraph 3 of the counterclaims, and it addresses an April 2021 email exchange between my clients, Mr. Khan, Mr. Rosales, and Mr. Herman. That April 2021 email exchange is actually attached to the counterclaims as Exhibit A. And if you look at that email exchange, it clearly falls within the scope of Section 59H, because what is happening in that is the parties are discussing the defendant's conduct with regard to the governance of Cambridge Towers. And Mr. Herman actually says, quote, "I'd be glad to consider any specific legal options." Now, the defendants claim in their counterclaims that this email is indicative of some sort of actionable misconduct that falls outside the scope of petitioning activity, but I would suggest it's actually quite the opposite. The language of the email itself indicates that it falls clearly within Section 59H's definition of petitioning activity, and also, if you go back to paragraph 3 of the counterclaims, where this email is referenced, that paragraph pertains to the timing of the complaint being filed, which again is quintessential petitioning activity, the filing of the complaint. The other issue that's unique to my clients that I want to address is also attached as an exhibit to the counterclaims as Exhibit E. This is first referenced in paragraph 114 of the counterclaims, And it's referenced in the context of an allegation that my clients allegedly, quote, intentionally blocked financing for needed repairs to the Cambridge Tower garage and parking deck. Again, if we actually look at Exhibit E, it's quite obvious what's happening there. So the first thing is my clients did not block the repairs. The revisions, Exhibit E was proposed revisions to a loan agreement between the bank and Cambridge Towers. If you look at Exhibit E, the very first paragraph, my clients continue to indicate that they consent to the loan. They have no objection to the loan. The revisions that are...
And your opponent puts a different spin on this, right? That they're suggesting unreasonable revisions to what should have been a simple consent form in order to block the financing of the garage repairs, right? I mean, that's what they're alleging. So the judge said that it's a factual dispute. Why isn't that correct?
Because I think, respectfully, Your Honor, that if we look at Exhibit E, those revisions all pertain explicitly to the already by that time pending litigation. There's references to the rights that my clients are trying to preserve. They want to, everything that they're requesting in those proposed revisions to Exhibit E are consistent with their petitioning activity and the relief that they're requesting in the original complaint. There is no effort there to go outside of what they are trying to do. They're simply just still trying to protect their interest as already then pending, and consequently that clearly falls within the scope of 59H2, which specifically pertains to that type of activity. Subject to your questions, I'll rest on the brief.
Thank you very much.
Thank you.
Good morning, Your Honor. May it please the Court. My name is Michael Stanley. I represent the appellees, Margaret Mashara, Beth Fishman, Jesse Zorfis, and the various entities that have been named in this case. Your Honor, the trial court correctly ruled that plaintiffs failed to meet their the small dissenting shareholders failed to meet their burden at stage 1 of Bristol Asphalt to show that my client's counterclaims were based solely on petitioning activity. We fully acknowledge that filing a complaint is petitioning activity, but the filing of that complaint was part of a larger scheme in which we've alleged in the complaint to extract concessions in the corporate governance of the Cambridge Tower Association that they otherwise would not be entitled to. Now, following Your Honor's, this court's decision in Sabatini and Nouse and Bristol, when there's mixed questions of claims that are based upon petitioning and claims that are based on non-petitioning activity, they're best left for the merits of, for a merits-based determination and not the strong medicine of the anti-SLAPP statute. Here, the trial court correctly applied that standard under Bristol Asphalt and Duracraft in making that determination. Now, Duracraft specifically says in conducting a stage 1 analysis that you look at the conduct alleged and the conduct alone, and to do so, you can look at the pleadings and various affidavits to determine whether the complaining activity is based solely on petitioning activity. Here,
is there any limitation to a court's consideration of affidavits at the stage 1?
I don't believe so. I think Duracraft is quite clear that, in I believe the quoted language is, we may look at pleadings and affidavits. I acknowledge that footnote 21 of Bristol Asphalt does say we can determine whether the affidavits you can use other documents to determine whether certain activities are petitioning activity or not, and I believe that the affidavits here fit squarely within the framework of Bristol Asphalt. The Zorfis affidavit details a conversation that Mr. Zorfis had with Dr. Rogers post-filing of the complaint. And if you look at, I believe it is volume 1, page 664 and 727, that's the Zorfis affidavit in the settlement terms offered by the term sheet presented by Dr. Rogers. Dr. Rogers in that term sheet is trying to extract benefits for which the dissenting shareholders could not obtain through any judicial process. They're trying to extract $1 million payment. They're trying to extract a transfer of ownership interest in a laundry room. None of those claims are part of the main complaint here. They're trying to use this lawsuit as a means to leverage benefits that they otherwise could not obtain. In the
None of those claims are part of the complaint, is that what you said? I thought in Rogers' brief, they said that Rogers did not offer anything that wasn't already requested in the lawsuit. Is that not accurate?
I believe that's not accurate. I don't believe the plaintiffs were seeking a transfer of the Alacrity Partnership laundry room in the lawsuit. I don't believe they were seeking $1 million payment for settlement of the lawsuit. Those are all part of the term sheet which he presented to Mr. Zorfis. And that is how the trial court looked at this complaint and the related affidavits. The trial court looked at it as saying, well, there was action before the complaint, the spreading of information regarding what the potential sale of the units would cause to the owners of Cambridge Tower, that their interests, their value may drop by 30%, that they would not be able to vote on, and I believe that the 52% voting block would block every type of voting arrangement for the company. So they spread that misinformation. That is not accurate. And I believe Mr. Khan or Mr. Herman specifically stated that 30% rejection was just a guess. Then the complaint is filed, and then post-complaint, Dr. Rogers talks with Mr. Gillespie, and he basically tells Mr. Gillespie, you're never going to obtain sufficient control to do what you want, even though you're buying a majority share. Later, Dr. Rogers then goes and talks to Mr. Zorfis and says, here's our concessions. If you want to sell this property for $20 million, this is what you have to do for us. All of this was part of a broader scheme that is in line with the Keystone Freight decision, where in that decision, this court found that there was essentially an inflated billing practice, and a collection lawsuit was filed. The party participated in that collection lawsuit and then uncovered that there was a scheme going on, and that lawsuit was used as an attempt to extract a larger payment than they would be entitled to.
Were you able to review Hidalgo?
I was, Your Honor.
Okay. So how do you respond to Hidalgo, essentially, which says that abuse of process claims are presumptively subject to anti-SLAPP dismissal, and they should be mostly decided at step 2 rather than step 1?
I think the distinction in Hidalgo resolved is present in the first paragraph of that decision. The first paragraph states that the court is assuming that the only complaint of activity is petitioning activity, is the lawsuit itself. That doesn't square with 477 Harrison 1 from 2017, the SGC decision, which says misuse of process is a type of claim, and the misuse of process is using process as a means to extort or as leverage to obtain something you were not lawfully entitled to. So that first paragraph of Hidalgo places a limitation on its analysis. I would agree with you that if there was no other evidence of misuse of that process, not using the lawsuit as leverage to obtain something you would not be entitled to, Hidalgo makes those abuse of process claims presumptively into stage 2. You can't get past stage 2. But the way the court phrases that in the opening paragraph, it says, assuming that is the sole petitioning activity, distinguishes it from this case, Your Honor.
Which 477 Harrison?
It's the 2017 one.
Okay, thank you.
So I think another point that draws this case closer to Keystone is my clients participated in the invocation of process for over 2 years. It participated in discovery. It didn't file a counterclaim for abuse of process saying your invocation of your right to file a suit was harmful to my client. It participated in the process, in the use of that process, uncovered the scheme through discovery, and then pled that scheme as a counterclaim. This isn't, and the court draws that distinction in Keystone too, where the party participated in that collection lawsuit, and then it uncovered the scheme, filed a counterclaim for abuse of process. Misuse of process is really what 477 Harrison says. there's essentially two types of abusive process claims, the invocation of process and the misuse of process. And we're dealing with the misuse of that process as part of a scheme to extort entitlements that the dissenting shareholders would not otherwise be entitled to. So applying the Bristol Asphalt and Duracraft framework, there are specific allegations in the complaint that pertain to this extortion scheme. And what we say is, you have to remember that a complaint is controlled by Rule 8. We don't have to plead every specific detail of the claim, and I think that's why the court allows for the uses of affidavits to describe what the petitioning activity, whether the claim is or is not.
Do you think without the affidavits, the allegations are adequate as to Rogers to survive the anti-SLAPP?
I do, and I think you come back to the Ehrlich v. Stern decision from 2009 from this court.
I'm sorry, say it again?
Ehrlich v. Stern, it's cited in our brief, it's also cited in Bristol Asphalt, that they say they're reviving what Ehrlich v. Stern. And what Ehrlich v. Stern says is that if you're gonna, you would apply the Rule 12b-6 indulgences, I believe the quote is indulgences, to the complaint to determine whether the claims are based upon petitioning or not. So if the affidavits don't exist, then you're in the Rule 12b-6 world where all inferences must be taken in.
But a bare allegation of conspiracy probably isn't enough.
I would agree a bare allegation of conspiracy is not enough, but for instance, I believe at paragraph 100, we allege the filing of the complaint and the dissenting shareholders' misinformation campaign accomplished the ultimate purchase. The prospective purchaser walked away. So in that instance, there's two distinct activities, the filing of the complaint and the misinformation campaign. And so what that misinformation campaign, I believe the court would have to infer, that is separate from filing the complaint, and it would be the activity that caused the prospective purchaser to walk away.
But that doesn't speak directly to Rogers' involvement, right?
Well, at that point, no, it does not speak directly to Rogers' involvement. That is...
So applying 12b-6 indulgences to the counterclaim, do you think it states a claim against Rogers?
I do, Your Honor, and so did the trial court, which Mr. Rogers moved to dismiss, and the court denied that. And that is not subject to appeal.
I understand that.
Your Honor, the trial court, I'll conclude that the trial court properly found that my client's allegations were beyond solely petitioning activity, encompassed a scheme to extort benefits they were not otherwise entitled to, and therefore properly concluded that the claim was not based solely on activity. The court should affirm the trial court's ruling and allow this case to proceed on the merits. If there's no further questions, I will rest on my briefs.
Okay, thanks very much. Thank you all. The case is submitted. We will take a 15-minute break.
Session to be seated.
All right, the next case is Department of Children and Families and Another versus Father and Others, number 2025P72. This case is impounded, so please just make sure not to use names.
Good morning. May it please the court. Colleen Duran on behalf of the appellant father. This case, Your Honors, is all about competing adoption plans. And what we know from adoption of Hugo is that when there are competing adoption plans, we need to follow the ruling case law under Hugo. The judge was required in this case to provide a side-by-side analysis of the two plans and make a determination as to what plan better meets the needs of the child. The judge in this case did not do this.
So I'm sorry to interrupt you so quickly, but you've touched on something that I was sort of perturbed by in reading. And you say that judge is required to do a side-by-side analysis. Where does that requirement arise from? Where does that? That's a terrible sentence. Do you know what I'm trying to ask you? Where does that come from?
Well, I believe, Your Honor, the detailed analysis is in the judge's ruling, the SJC ruling in the case of adoption of Hugo, where there was a very detailed analysis done by that juvenile judge. And if I can tell you, in this case, Your Honor, what the judge did do was basically looked at 4 factors that were brought up and raised at trial by the department. That the child has been in the foster home for a long time, the child does not want to leave the foster home, the foster parents have been doing a good job, and the paternal great aunt, which is the adoption choice for the father, does not know anything about the child. And although some of these factors may be true, the judge states first, the child's been in the foster home a long time. This court has already spoken to that matter, that the passage of time cannot be a factor. Could have been delays by the department, court delays, father requested a continuance of trial, but passage of time cannot be a factor in the analysis.
Counsel, I just want to let you know, I believe the clock started at 10 minutes and not 15 minutes. So you actually have 5 more minutes than what the clock displays.
Thank you. And the second point, child does not want to leave the home. This is typical. Children often get very comfortable in the home they're in when they're provided with shelter, food, and comfort. And the child's obviously bonded with the foster parent. But in Hugo, it also stated that if a child can bond with one family, it certainly shows that they can possibly bond with another family, and she could be bonding with the paternal great aunt, PGA. The third point, foster parents are doing a good job. There's no doubt that they're doing a good job. But the analysis that this judge did not do was everything that PGA could do for this child compared to what the foster parent was doing. And the fourth point, PGA does not know the child. We have many cases, Your Honor, where family steps up on the eve of trial and says, I want that child. This woman, PGA, stepped up 4 years early before trial in 2020, and she said, I want that child. In this case, there were 3 children. 2 of the children, 2 sons, did go with Father's Choice PGA in Florida. The daughter did not. And again, the department's plan was for her to stay with her foster parents. The judge in the juvenile court also determined in Hugo that the aunt in Hugo had been very heavily, consistently, and directly involved in the treatment of her own son and had special needs. And the same can be said for PGA, who also did the same for Father's 2 sons. Those 2 boys came to PGA, and you could say that she didn't know much about the boys at the time, but she quickly learned those children had transitioned through multiple foster homes, with one child transitioning through 13 homes. She did so much work for these 2 children between their education, therapy, psychological needs, medication for one child. The findings are missing that analysis. Even though the judge clearly outlines what the foster parent and PGA did for each child, and for PGA for the 2 boys, that analysis that PGA did this work and could she do it from the daughter is missing. The department also argues that the child is of the age where she can block an adoption. However, this court's already spoken to that. It is a consideration, however, it's not outcome determinative. And it doesn't mean that the child won't change her mind. And I believe this court's also spoken to, we can't have 12 and 13-year-olds dictating the outcome of a case. Important in Hugo, that child was placed with the foster parent at the age of 3 months. It speaks to this case because the child, the girl, was with their family for 7 years. So this judge should have pointed out that there was a connection with the family. There was a connection with their siblings. The department also points out that the child's bonded to her foster siblings. These aren't her biological siblings. Her biological siblings are her two brothers that are living in Florida, who she did live with for a period of time before removal. The department also mischaracterizes PGA's good intentions, because they said, or they alluded to in their brief or trial, that PGA was not willing to take 4 children. PGA was taking the biological children of father. There was actually 5 children removed, the initial removal. 2 had aged out at the time of trial. Those are mothers, 2 older children. PGA made it clear in March 2020, 4 years before trial, I want those 3 children.
So why wasn't it reasonable for DCF to decide to go forward with the interstate compact only for the 2 boys, where at the time they were making the decision or they were starting the process, this child's older sister, bio sister, was in the same foster home with her?
That is true, Your Honor, and it's very important with the ICPC. I thought that was another important point, because in Hugo, the judge also pointed out that when the Inat initially came forward, the department didn't initially move on that or pursue it. They did later. The department here made their decision in June 2021 when the child was only 10 years old. She couldn't block an adoption at that age. 2021 in June, they went forward with the ICPC, didn't include the daughter, and they never amended it. And the older sibling, the daughter that lived with her, they knew, the department, that this daughter had multiple behavioral issues. She transitioned through many homes, and she actually left that foster home with the daughter to be placed in residential placement. There was never an intention for that family to adopt this child. Again, when that happened, Your Honor, the department never amended their ICPC to include this daughter. Other points that are also brought up in Hugo, I think, is important. They alluded to the department, in a sense, in their argument in that case, why fix something that's not broken? We've often found that there are times when the best interest of a child warrants fixing the child's custodial relationship. Again, what's missing here? There's 277 findings. I believe they're broken down into 20-plus sections. There's no section that says what the placement option for child and the determination for best interest. That is missing. Again, the judge does a fine job of outlining what the foster parent did and what the PGA did. However, there's no comparison. In conclusion, Your Honors, I just want to say that this case involves a father who stepped up early in his care and protection case and said, although I love my children, I cannot parent them. All I ask is that you follow family first, and he made a great recommendation for his 2 sons and his daughter, which the department did follow through with his sons, PGA in Florida. What the department did do to this man, he proposed a solution in March 2020. His daughter was only 9 or 10 at the time, and it was to go with PGA. And she's obviously been an excellent choice, as she proved of what she did do with these 2 boys. But what the department did do was string this man along for about 6 years. This man went to a trial that he didn't want to go to. He said early on, I love my children, but I can't parent them. The judge obviously thought that PGA was a good adoption choice for father's 2 sons. However, why not for his daughter? But we don't know that, Your Honor, because the juvenile judge in this case did not follow the controlling laws outlined in Hugo and provide us with that important analysis. And for all these reasons, Your Honor, Father requests that this court vacate the judgment as to approval of the department's adoption plan.
I have a question for you about your visitation argument. Are you arguing that the father has standing to request visitation of the older boy about whom it was determined he's not the biological parent?
It is true that it's not his biological parent, Your Honor, but Father made it clear that he loved that child, regardless of being his biological child. I believe that Father does have standing because he did proceed with the trial, he did participate in the trial, and he advocated for all 3 children. If there's nothing further, I will rest on my brief. Thank you very much.
Thanks very much. We'll hear from the department. I understand you'll be splitting your time, 10 minutes, 5 minutes?
That's right, Your Honor.
Okay.
Good morning, Your Honors. May it please the Court, Claire Gilchrist for the Department of Children and Families. The Department is asking you to affirm the orders of the lower court today, terminating father's parental rights to his daughter and son and declining to order post-adoption visitation, as well as approving the Department's adoption plans. Here, the court did exactly what it was required to do. It carefully evaluated the two competing plans in front of it. It made 60 findings of fact concerning the children, their needs, their placements, and the plans. It made 6 detailed findings specifically concerning the paternal great aunt, and in its conclusions of law, it had, in 4 different conclusions, discussed the plans, and in conclusion 38, it had 5 single-spaced paragraphs comparing each plan and the best interests of the daughter. So the standard here is an abuse of discretion, and the judge acted within her discretion here in approving the plan, the department's plans. As far as visitation, father appeals the court's decision not to order visits with his children. Again, the judge acted properly. The evidence was clear that father's daughter had not visited with him for, I believe it was 3 years. She hadn't wanted to, so there was not a bond there that visitation would further her interest. And as far as father's son, he also at one point had declined a visit with him, about a period of 6 months, I believe. And in the almost 2 years leading up to trial, father had only visited 4 times with the child. So there was not a bond there either, which would indicate that it was in the best interest of the children to continue visits post-termination.
Is there a mechanism for any of the children to request a more specific sibling visitation order before the trial court?
Yes, Your Honor, they are able to return to the trial court if they choose and file a motion in the trial court to request a modification.
At any time?
At any time, yeah. My understanding, though, is, well, I think my sister will speak to this, that she may not be seeking such an order. So I think, the judge looked at the individual and particular circumstances of each child, and we know from adoption of veto, that's what she was required to do, and so she had an individualized inquiry. And those are clear from her findings. If there are no further questions, I rest on my brief.
Okay, thank you.
Good morning, Your Honors. May it please the court, my name is Dana Shenevert, and I represent the child. And she would ask that this court affirm the judgment in all respects. And initially, just to speak to what my sister just said, I would respectfully like to withdraw our request for remand concerning the sibling visitation order. That issue is no longer before this court. The focus of the child's argument is essentially we're aligned with the department, so I don't want to waste the court's time by reiterating things that my sister has said. But I do want to say regarding the plan, since I am representing just the girl, that the court made 9 findings, 263, 264, 267, 268, 270, 271, 272, 273, and 5 conclusions of law, 11, 14, 18, 31, and 38, that demonstrate that the lower court carefully weighed the competing plans. And the findings and conclusions reflect a thorough and reasoned and even-handed assessment of the plans in favor of the department. The court's conclusion that the department's permanency plan
provides the child with stability and safety and continuity of care are outcomes that father's plan just could not guarantee. Now, we're approaching the 7th anniversary of the child's placement with this family. She turned 14 back in February 2025, which means she has spent nearly half her life with this family in this home. Now, by the time the trial ended in April 2024, she was already securely bonded to this family. That is amply supported by the record. All of them, the parents, the foster children, or the foster siblings, and even the pet, the family dog. But it is not simply the passage of time that makes this placement the better one for her. It is the depth and the stability of the relationships that she has developed in that home, the care, the consistency, and the permanency that this placement provides. This is what uniquely meets her needs, then, now, and going forward. And this is amply supported by the record. The lower court did not make mistakes here. So the case has been ongoing since 2018, and my client wants and deserves permanency. At 14 years and 7 months, she has clearly and repeatedly expressed that she wants to be adopted by this family, and she wants to move on with her life. And for these reasons, we would respectfully ask this court to consider issuing a notice of decision on an expedited basis, perhaps through a notice of decision with the opinion to follow, so that this child can reclaim her childhood and she can finally have the stability and the security that she has wanted for so long.
Can I just, oh, go ahead.
Your client testified at the trial, and the judge believed her when she said she wanted to be with the adoptive family. Is that correct?
That is correct. The court credited her testimony, her wishes, and her desire. And as we know, this court just takes those credibility assessments. Where there is no evidence to determine that the credibility assessments are just an abuse of discretion, this court just takes those as it should in this case.
I understand that you are no longer requesting remand to address the sibling visitation issue. There's also a finding by the trial judge that the pre-adoptive parents, or this is number 277, are committed to post-adoption visits between the girl and her brothers. I take it there's no reason to believe that has changed. In other words, that the pre-adoptive parents are still willing if the girl wants it.
That's correct. So if there are no further questions, I would just rest on my brief.
Okay, thank you very much. Thank you all. The case is submitted.
Thank you.
All right, the last case is First Horizon Bank versus Julianne O'Donnell and others, number 2024 P943.
May it please the court, I'm Jason McGuire and I represent the appellant Julianne O'Donnell. I'm going to take Justice Chin's advice and get right to the point. This entire case is tainted by the judge's ruling that the dismissal was with prejudice as it relates to Julianne O'Donnell. That is where it stands. The judge was given an opportunity to clarify or correct his ruling, and he stood on it instead of clarifying that Mr. O'Donnell had been dismissed with prejudice from the prior action, and Mrs. O'Donnell had been dismissed without prejudice in the prior action. That, in our view, taints the entirety of everything that occurred after it. This case is, because Julianne O'Donnell's dismissal was without prejudice, it doesn't meet the definition of a final judgment on the merits because it was not, the judgment that was issued in the lower court was not subject to appeal. It could not have been appealed at the stage that Ms. O'Donnell filed her and negotiated her dismissal without prejudice. First Horizon's predecessor in interest had every opportunity to negotiate better terms and say, no, we're not letting you out of this unless you're dismissing with prejudice. They did not take that opportunity. They assented to the dismissal without prejudice as it was to Ms. O'Donnell.
Well, it seems reasonable to assume the reason they assented is they thought the only remaining claim was the 93A claim.
You could make that argument, yes, Your Honor.
That's how the judge seemed to construe the voluntary dismissal.
I don't know that that's entirely correct because the judge didn't correct his error. I mean, it's clear that his opinion says the case was dismissed with prejudice. And, you know, I get that trial judges are very busy and lawyers routinely file motions for reconsideration that don't meet the rules of civil procedure, and so they probably don't get the attention that maybe they should. I mean, trial judges, they have infinite patience. You ever sit through a hearing where there's multiple interpreters? It's painful. So they have a lot of patience, but when lawyers abuse the motions to reconsideration or vacate, it probably hurts clients like mine.
Well, what the judge said was the parties resolved the remaining consumer protection claim by stipulation, dismissing it with prejudice, which that's erroneous. But the judge was specifically referring to the 93A claim. I mean, I can't think of any reason why the predecessor would have assented to a voluntary dismissal of two claims which were already resolved on the merits.
In its favor.
I mean, it still begs the question to me how to characterize what happened to those two claims. But the judge seems to have reasonably construed the dismissal to apply only to the 93A.
Then summary judgment could not have entered on the consumer protection claim.
Sorry?
Well, by your reading, Your Honor, the consumer protection claim for Julianne O'Donnell survived from the Superior Court action, correct?
Correct. But the two claims that dealt with the foreclosure and ownership were resolved on judgment on the pleadings before that.
Partially, yes.
So those are the two claims that are relevant that the judge found precluded the arguments in this case.
Well, I think, Your Honor, in the Superior Court decision, there's been a lot of misconstruing the Superior Court decision. Specifically on the record appendix, page 95 is where it is. And there are still claims that were available and made by my client in the summary process action that weren't addressed in the Superior Court decision on the pleadings.
Counsel, I have a question, excuse me. The bank cites to a case, a 2016 case from this court, Santos versus U.S. Bank National Association, for the proposition that a party cannot unilaterally reserve rights in this situation by basically doing what your client did here. How do you distinguish that case?
I distinguish it, Your Honor, because again, even if you follow Santos on that point that they can't reserve rights, then my client didn't necessarily need to reserve her rights because she dismissed without prejudice. She dismissed prior to entry of final judgment, prior to when the decision of the Superior Court was able to be reviewed. It was never able to be reviewed, so it doesn't qualify as a judgment on the merits.
Well, I don't think you can I'm sorry. I don't think you can dismiss without prejudice just by voluntary dismissal. I think it has to be a stipulation.
And it was stipulated
And
by,
again, I think that goes to the 93A claim, not to the two that were already resolved.
I don't know that the record is sufficient to make that claim. I mean, that is certainly the bank's position and their predecessor's position that those claims weren't dismissed, but given what was filed by Julianne O'Donnell as her dismissal, I don't know that that's a reasonable position to take, because the bank should have spoke up and said, hold on a second, we're only agreeing that she can dismiss without prejudice to the 93A claim.
So let's take this, let's assume you're right about that for the sake of argument and take the next step. So let's assume we're in this really weird procedural posture where your client lost on the merits, but no judgment entered. Just put the 93A claim in a box over there, all right? We're not concerned with it. She lost on the merits on the foreclosure action. Bear with me. Maybe
Yes, Your
you
Honor.
disagree. But there was this weird little tango about the dismissal, and what ended up entering by agreement was a dismissal without prejudice, the contours of which are unclear, but which in a strict term is not an adequate basis upon which to rest a res judicata ruling. So let's say you win, and then you go back and a judge just looks at all of the papers, and I mean, where does that get you?
Oh, it gets me to a determination. Well, when the judgment on the pleadings entered, the foreclosure had not occurred. It had, well, actually, they occurred the same day. So the judge could not have ruled that the foreclosure that occurred the day that his judgment entered was proper. The judge could have ruled that certain steps on their way to the foreclosure was proper, but not that the foreclosure itself was
Right.
proper.
Sorry,
It hadn't
you're right.
happened.
I misspoke. So the thing that was decided unfavorably to your client, but as to which no judgment issued, at least according to your theory, was not that the foreclosure was okay, but that the Wilmington Savings Fund, whoever the holder was, First Horizon, actually held the deed.
Yes,
right?
Your Honor. But there are, and that they also ruled that the CMR 240, I forget the actual.
The notice provision.
Yes, but the note certification, the Superior Court ruled that that was proper, and that the chain of title was proper. That wasn't a ruling that the default notice was proper. It wasn't a ruling that my client had been properly evaluated for loan modification in an effort to avoid foreclosure. It didn't rule that the communications between the servicer and my client were not violations of 93A. So there are still numerous challenges to the foreclosure that weren't ruled upon in this order. And I didn't handle this case at the trial court level. I got into this because my partner's out of country. And when I'm reading this, with fresh eyes and going back to page 95 on the appendix and looking at what is said throughout the course of these proceedings, it doesn't match what is on the page on page 95 of the appendix. And that, I think, is the crux of all of this, is when characterizing what the court said at the Superior Court level on the judgment of the pleadings versus what the hyperbole is over what was actually determined on this record, I think is disingenuous. I think some of it is an exaggeration in taking it to the next level on the part of First Horizon throughout this process. Because in preparation for this, I read every page of the appendix, every pleading that went along with this, and I go, okay, I got page 95 here. This is what the judge said. That isn't what you said the judge said. So there's been, I think that it comes down to, if it comes back to us, goes back to the trial court, what did the judge actually say at the Superior Court? I think that the housing court judge needs to look at what was said in this decision, what was actually determined. And that's putting, Madam Justice, that's putting aside, like you said, this weird procedural issue we have of without prejudice and the dismissal. It doesn't meet, at least as defined now, a determination on the merits, because when she dismissed without prejudice, she could not have appealed. Had she, and as my brother pointed out in the brief, if she filed a notice of appeal from the judgment on the merits, it would have been thrown out because it was premature.
Did she have the power to dismiss without prejudice, given that Judge Barry Smith had already ruled for judgment on the pleadings on counts 2 and 3?
With the assent of the other parties, yes. Because final judgment had not entered. And she got that assent from the other parties. I think that this is a situation where First Horizon needs to look to their predecessor and go, you screwed up. You handed us this, and yeah. I mean,
Your opponent argues in the alternative that we can affirm on the merits. What do you respond? What's your response?
I don't know that the record is necessarily fleshed out enough to.
Well, it was raised below. There was a summary judgment motion that raised res judicata and then the merits. So they're entitled to come up here and ask for affirmance on that alternative ground.
I don't believe that I don't believe they met their burden to show that the foreclosure confirmed with applicable law as it relates to the default notice and as it takes an account for the 2015 modification of the mortgage. I don't see where they met their burden to enter summary judgment based upon those two facts alone. And so I have 2 minutes left. Do I need to get into the whole use and occupancy thing, or?
If you'd like to.
I don't really want to, because I don't want to set precedent. But this is an issue that I think is going to be on the forefront in the coming years. If you go past the res judicata and into the use and occupancy, this issue is going to start coming up more and more. Up until now, in my experience, because my firm does a lot of foreclosure defense. We have never entered into a situation where a damages award was given from the time of foreclosure to the end of the trial based upon use and occupancy for the withholding of the property during that time because the title had not been decided. The case law is fairly clear, and my brother makes that in his argument in the brief that the case law is pretty clear. Use and occupancy can't be ordered until after title has been determined.
Now it has been determined.
Now it has, yes.
Yeah, I mean, the cases you cite seem to be dealing with interim use and occupancy, but now that title has been determined, why isn't a past damages award appropriate?
Well, for one, they didn't bring the claim until 2 years later. So they can sit on their rights and to the detriment of my client for 2 years while...
Well, she's not paying anything, so I mean, I don't know what the detriment is.
Well, there's also, most of the cases deal with a landlord-tenant issue, and in those issues, there is something that the plaintiff in the summary process is doing. It's an affirmative action, maintaining, upkeeping, keeping the property in proper working order, shoveling the snow, whichever. That is not a case in a post-foreclosure action. And I am out of time, and I will rest on my brief otherwise. Thank you very much.
Thank you.
Still good morning?
Yes.
Just double checking. Good morning, Your Honors. My name is Liam Floyd. I represent First Horizon Bank. And the central, I think my brother did put it, the appropriately argued about that the central argument is whether and when res judicata attaches. It seems pretty clear. This is a classic example of somebody making tactical decisions to get another bite at the litigation apple. The first case was they brought the same set of arguments, which is problems with the chain of title, problems with who owns the actual mortgage, and subsequently a summary process action was brought, and they determined we're going to bring it over here, the same case. But they had already brought the case in the Superior Court. Superior Court had already made a decision that, based on their proffered evidence, they did not have a claim. Under the innumerable amounts of res judicata, and I tried to keep it very brief in my brief, but a good example is the Santos case was alluded to, and Torres v. Palmer, that that we don't need a formal, final, stamped judgment for res judicata to attach. There simply needs to be an argument, a chance for the parties to fight it out in front of a fact finder. This is Torres v. Palmer set it forth. They fight it out, and a judge makes a reasoned decision. We can argue, we can disagree or agree with the decision, but there is a single-space, two-page decision in the record setting forth all the details of why in this case, the plaintiff's case, the O'Donnell's case, failed.
Well, let me just, I'm sorry, go ahead. Yeah. Let me just push back on what you said. There does need to be a final judgment, at least for purposes of claim preclusion.
And there was one in Jaros versus Palmer, and there was also one in Santos.
Right. But in this case, there was a decision that was finalized, and they had the opportunity, the last element that I didn't get to was they had the opportunity to appeal. There were multiple...
From what?
From the motion for judgment on the plaintiff, I'm sorry, the order on judgment on the pleadings. She could have done...
That was an interlocutory order, right? Because there was still
Correct.
a remaining claim.
Correct.
So why wouldn't any appeal at that point have been dismissed as premature and not an appeal on from a final judgment?
I'm not arguing, well, two things. She could have done an interlocutory appeal, which is open to anybody who has that objection. Secondly, she could have continued that action, the Superior Court action, till it was a final judgment, and then brought the appeal from the final judgment.
Of course,
There's nothing, but she opted instead to strategically, after losing that there, to bring the same claim, same issues, same parties, to a different...
well, I don't think she made that choice. Didn't your client sue in the housing court?
Yeah, no, the First Horizon brought the eviction action in the housing court. I'm saying that she then determined when that case was brought to then dismiss the Superior Court case so that she could focus on the summary process case.
And she determined to ask for dismissal without prejudice, and your client's predecessor in interest agreed.
Correct.
So that dismissal was without prejudice, which makes it non-final.
I disagree in that she made the decision she made a tactical decision to change, to not appeal that decision in the Superior Court and bring it in, so that the whole point of the concept of claim, we're really, put a fine point on it, we're talking about claim preclusion rather than res judicata. Perhaps I should have been. And we throw these terms around, they're somewhat interchangeable, but I think it's important now that I'm putting a finer point on it. This is a claim, my argument is claim preclusion. The claim was already argued, and she lost. She simply then dismissed it and brought the same claim over here. The argument is that she could have appealed that argument. She could have gone through the process and brought an appeal here from the Superior Court.
But it's always true when your case is ongoing that at some point your case will be over and you could appeal.
Yes.
Right? So her case was ongoing. That was not a final judgment subject to appeal. Now in a parallel universe, perhaps someone, maybe your client's predecessor in interest, could have asked for a 54B judgment. And then that would have been final with respect to the claims that were decided by Judge Barry Smith.
Right.
But nobody did that. So in the absence of a 54B judgment and in the absence of a dismissal with prejudice, what makes that decision in the Superior Court final and appealable as is necessary for claim preclusion?
It was appealable. It was a decision in the Superior Court, and it was appealable. We're arguing about when it was appealable. It was ultimately an appealable decision. She had the right to appeal that decision, not at that moment, but once final judgment, a couple of extra procedural steps had entered, she could have appealed that decision. She also could have appealed it instantly through the interlocutory appeal process.
When did final judgment enter in that case?
Some point after, I'm not sure because there was that, the husband still kept it going for a little bit longer. So I'm not 100% sure when that occurred.
I mean, she could have appealed. She also could have dismissed the case with the assent of the other side, which seems to be what happened. Right? I mean, I don't think she could have dismissed it without the assent of your client's predecessor. But there's this weird assenting email, and what entered on the docket in Superior Court also reflects assent. So it was dismissed without prejudice, right?
Ultimately, it was dismissed without prejudice after, but the procedural posture of the case, by the time it was dismissed with prejudice, was that those two claims regarding the mortgage, I don't remember the numbers here, but exclusive of the 938 claims, those two claims had already been dismissed pursuant to 12C.
Right, but so how do you characterize the final disposition of those two claims? What happened to them?
They had been dismissed pursuant to Rule 12C.
Dismissed with prejudice or without prejudice?
I would argue with prejudice.
How are they dismissed?
Well, I guess they were dismissed subject to the plaintiff's right to appeal through interlocutory process or through continuing the case. She had the right to appeal.
Let's put aside the potential appeal. Just based on what happened procedurally, how do you characterize the dismissal of those two counts? You say with prejudice. How do we get there?
They were dismissed. I get there because the court had decided that those two counts did not, essentially they were dismissed under the same aegis as a motion to dismiss. And a motion to dismiss would require her to is in offense a judgment that that she can't bring that again because it's already been determined that that claim is not a valid claim. So I'm not, they don't use the same language in 54 and 12. They don't track. But under Rule 12, a court has made a ruling that this case is dismissed.
Well, I mean, the thing I see on the docket from the Superior Court case, which was not included in a record appendix, is on March 5th, 2020, notice of voluntary dismissal, 41A11, and then order of dismissal nisi entered after action was reported settled on March 12th of 2020.
I believe that the order Nisi refers to the Chapter 93A.
No, I think it refers to the other party.
It refers to the
As
husband,
to
who's not a
Brian
party in this case.
O'Donnell, yeah.
So again, I'm arguing issue preclusion, not res judicata. I'm not saying there was a final absolute judgment, but where a case has been determined, where a claim has been raised and it has been denied by the same parties, same issues, et cetera, the doctrine of issue preclusion precludes somebody from bringing the same issue in a different court.
I mean, I grant you that this is a very odd, very, very odd procedural posture, and that smells like preclusion. But let's say instead of what was filed, the voluntary dismissal with the assent, let's say what they filed was a stipulation signed by all parties, stipulation of dismissal of all claims by this plaintiff without prejudice. That's filed. And then Julianne gets dismissed from the case. Would you agree then it would not be preclusion?
It would not be res judicata, but I'm not agreeing that it's not issue preclusion because there's already been a finding by a judge.
Now your client's predecessor has signed on to a stipulation of dismissal of all claims without prejudice. You're saying that it's still going to be claim precluded when they've stipulated to a dismissal without prejudice?
It's not, first of all, I'm not conceding that that's exactly what they stipulated to, but...
No, I'm not either. I mean, this is just hypothetically, let's say that's what was filed.
Yeah. The word weird is appropriate here, but I do believe that claim preclusion attaches once a court has made an order of findings regarding a specific claim involving the same issue, same parties, et cetera, et cetera. So I think issue preclusion is already attached to that claim, regardless of how people want to characterize it. It seems to me that to argue otherwise runs counter to the very purpose of the doctrine, which is getting people multiple, having the same issue argued in multiple courts. Again,
I don't disagree with that. It's just weird. It's a very weird situation.
I think the problem is the assent, right? Because she couldn't have dismissed this without prejudice without assent.
Correct.
And there is an assent, so it seems comparable to a stipulation of dismissal that's signed by all parties.
But I would interpret, again, the assent as to only the 93A claim because they didn't need to assent. It's, again, it's weird or it's not clear, but the only logical inference is the bank has already won. We've won those two on those two counts. So we won count 1 and 2. We'll happily dismiss count 3, assent to count 3. Who cares? That's the only logic. I'm granting you the word weird, and that comes up, but it's quite clear the only logical inference is that the bank was, yes, we've already won on count 1 and 2. She wouldn't have been able to proceed. As a practical matter, let's game this out. Assuming the bank that thing didn't enter, she would have only had the 93A claim extant. She couldn't be arguing that. She couldn't, those are gone anyway. So you can't, so here's just came to me, thank you, that the argument is that they couldn't even have the power to dismiss a claim that had already been dismissed by the Superior Court. The court had already ordered that. So to the extent that anybody wants to infer anything else, it's a nullity. The only claim existing at the time she entered into that, she filed that notice of a dismissal, the only claim extant was the 93A claim.
But this is a nerdy business, right, that's practice of law. And so what we have in front of us is a ruling on the docket from Judge Barry Smith saying, consistent with this order, the sole remaining claim is plaintiff's claim for unfair or deceptive conduct in violation of 93A. So absolutely that supports what you are arguing. But we also know, because we are nerdy lawyers, that judges saying things in orders on the docket, in findings and conclusions, is not the same as a judgment entering. That does not end the case. In order to end a case, they need to enter something called a judgment, and that didn't happen here.
Which is, again, why it's a claim of issue preclusion, not res judicata.
That's the argument. That you don't need, for issue preclusion to attach, you don't need a final stamped.
But aren't you the guy who just said like 7 minutes ago, my issue is claim preclusion? Let's be more precise.
That's what I'm saying. It's claim preclusion, not res judicata.
Okay, you just said issue preclusion.
Forgive me.
That's all right.
And then, since I'm out of time, I would just reiterate in my brief that this court has plenty of authority to revisit the original motion for summary judgment that is completely set forth in the appendix. And it's based on the same set of facts that were argued in the Superior Court, and I see no reason why there would be any different outcome in any event. Thank you.
Okay, thank you. Thank you both. The case is submitted. That concludes our sitting. Thank you to the court officers, clerk's office, our timekeeper, and our amazing IT staff.
Thank you, everybody.
Court all rise, please.